Part 3. Financial Matters and Possible Need for a Conservatorship. Many of us neglect making preparations in the event we are unable to make financial decisions for ourselves. We may know someone who is in this situation from an unfortunate accident, but we believe this could never happen to us. As with other matters covered by this video, it is best to make preparations in advance. This simply means setting things up so that someone you trust is able to help you with your finances without anyone mixing their finances up with yours. This is a gift you can give your loved ones to make their life so much easier in caring for you and your financial affairs. You should review your prior arrangements perhaps every year to make sure they remain current. You can also rescind or change anything at any time to meet your changing needs and choices. Most advanced documents can be voided by destroying all of the copies and by following the same process as when first executed. The basic requirement for preparing arrangements in advance is that the principal person and the agent must demonstrate sufficient mental capacity at the time of signing the document to understand what they are signing and the possible consequences. Throughout this part related to financial, we mention the principal person. This is the person giving their authority to someone else. The agent. This is the person who the authority is given to and who accepts this responsibility on behalf of the principal person. Fiduciary means someone with a special responsibility of trust and confidence for another person to make decisions for the benefit of that person. Court-appointed conservators. If we do not make preparations in advance for someone else to make such decisions for us in the event of our incapacity, a court-ordered conservatorship is the most drastic measure that can be taken to financially protect an individual. This is also used to protect someone from undue influence, exploitation, or fraud. Such a court order will restrain the protected person from making the most basic of unsupervised financial decisions and transactions. This removes the individual's right to make decisions related to finances, property, and assets. Conservatorship is a last resort when the mental or physical capacity is so impaired that a court-appointed conservator should make their financial decisions. If there isn't a family member or friend available, the appointment will typically go to a corporate entity, which will assign a caseworker. A corporate entity will bill the accounts of the protected person to obtain compensation for their services. This is also true for the expenses of the legal process for a court-appointed conservator. If the protected person makes a recovery sufficient for them to recover their own financial decision-making, they must first apply to the court for a review of their case, prove to the court that they are no longer incapacitated, and for the conservatorship to be removed. By preparing for the event of incapacity, many people successfully avoid the bureaucratic stress, financial expense, and risk of indignity associated with a court-ordered conservatorship. There are several financial tools that are relatively easy and inexpensive to obtain. A basic principle is that there can be no commingling of funds, property, or other assets of the principal person with those of the agent, fiduciary, or conservator. An accounting must be maintained showing any and all transactions. While the agent, fiduciary, conservator may receive payment, it may only be as specified by the principal person or by a judge. All transactions are only for the benefit of the principal person and cannot be for the self-interest of the agent, fiduciary, conservator. Anyone suspecting possible exploitation should immediately report it to the authorities. Alternatives regarding financial matters and to court-ordered conservatorship. This video is not intended to provide legal advice, and we strongly encourage you to seek advice from an attorney. The alternatives you choose should be specifically designed to meet your needs and to protect your interests. These documents typically allow someone else to make decisions for you, and you should specifically cite the extent and limitations for such decisions. Be selective and careful on who you give this authority to, and be cautious with what type of decisions they can make for you and when. The designated decision-maker should not be someone with a conflict of interest where their personal self-interest could possibly influence their decisions for the patient. You may specify what reports must be made to whom and when. Likewise, you may specify that certain decisions must be approved by a third party. This may provide some checks and balances to discourage possible wrongdoing. Many of the terms used in these documents may have a legal meaning which you may or may not be familiar with, and you may want to ask an attorney to explain them to you. You should not sign a document unless you completely understand it. Try to understand how this may be used in the future, particularly when situations change. Do not allow someone to force you to sign documents, and feel free to report this to the authorities. The following may help in preparing for the event of incapacity and are relatively easy and inexpensive. Negotiation and mediation by a third-party professional. This is useful to resolve family disputes or to help reach agreement. All concerned should participate in this and agree to be bound by the final agreement. This assumes the principal person is able to accept guidance and their side will be fairly considered. For example, the principal person agrees to a plan of care and living arrangements, voluntarily cancel or relinquish possession of credit cards, stop driving and begin to use other forms of transportation, possible solutions regarding financial matters, co-ownership of property, joint tenancy on real estate and other assets. This is a tool used frequently between spouses, but much more caution is often required when used between non-spouses. This involves a change to the title or deed and can result in unexpected liability to the principal person for actions of the co-owner. Mutual agreement is required to rescind, revoke the co-ownership and restore to sole ownership. For example, this requires a deed back to the original owner by the co-owner joint tenant. Representative payee. A trusted person is permitted to receive your monthly deposits for the purpose of paying all of your necessary bills. This is frequently used to handle monthly pensions, Social Security, or veterans benefits and institutional Medicaid. This is approved by the agency sending the funds and requires submitting an application. Any interested person may notify these agencies that the individual lacks capacity to manage their funds. Being appointed as a guardian or having a power of attorney does not automatically allow you to be a representative payee. This does not require mutual agreement by the representative payee to cancel it. Bank account signatory. A trusted person, such as a family member, is registered with banks and other financial institutions as signatory, often referred to as co-signer, and is given check-writing authority for the benefit of the principal person only. This is convenient if the owner of the bank account is ill. No ownership interest in the account is passed to the signatory, and there may be legal recourse by the principal person if signatory exploits the account. Terminating this does not require mutual agreement by the signatory. A durable power of attorney and a beneficiary designation is another option related to bank accounts and other assets. A separate, smaller account may also be established where the individual can have some independence and manage some of their money for daily expenses. Bank account signatory is different from co-ownership of a bank account or other assets. Co-ownership comes with significant risks. Co-ownership of any asset is often called joint tenancy and actually gives the other person ownership of the account as if it was their own. Co-ownership should be avoided unless that is truly the intention. A co-owner becomes an equal owner and will own the entire amount upon the death of the principal person. This may change the intent of a will. Another problem with co-ownership is that creditors and lawsuits may be able to use that to pay off debts or damages of the other person. The other person's spouse may also claim this money or assets as part of community property. Unlike co-ownership with a power of attorney or a bank account signatory, the other person does not own the bank account or asset, and the other person's creditors, lawsuits, and spouses would not gain access. With a power of attorney or a bank account signatory, after your death, the money or assets will be distributed as you directed in your beneficiary designation, and the person with the power of attorney only gets what you specify, if any. Also, keep in mind that a power of attorney is no longer effective after the death of either the principal person or of the agent. A will is not effective until the death of that person. Financial power of attorney. This is a legal document executed by the principal person who designates an agent to make decisions for them. A POA gives someone else the power to act on your behalf. This may be useful when you become too ill to handle your affairs. A spouse may need a POA to transfer property held jointly. You may designate 2 alternates as backups for when your primary agent is not available. It is commonly recommended that the person you designated to make your medical decisions not be the same person you designated to make your financial decisions. Medical decisions are quite different from financial, and again, be selective based on their experience and knowledge, their availability, and who you trust. The principal person must demonstrate sufficient mental capacity to execute the POA, which means that they understand what they are signing and its possible consequences. The agent should try to make the same decisions the principal person would make for themselves. Executing a POA after severe mental impairment will likely result in challenges to its validity. Durable means it's still good once the person is incapacitated, and springing means it's only good once the person is incapacitated. A POA will end upon the death of the principal person or agent. A financial POA can be broad or specific and must be notarized, and best if prepared by an attorney working for the person based on their specific needs. Be careful if someone else has prepared a POA for your signature without your direction. Anyone suspecting possible undue influence, exploitation, or fraud should immediately report it to the authorities. A POA is different from an advance health care directive that does not require that it be notarized. Witnesses signing the POA may strengthen its validity, but is not required by state law in New Mexico. A broad POA encompasses both routine and unexpected transactions, while a limited POA only encompasses the transactions designated. A limited POA may also be limited to a specified period of time. Terminating and/or canceling a POA does not require mutual agreement by the agent. The principal person must make sure the agent knows where the records and important papers are kept. A POA involving real estate transactions must be recorded with the county clerk where the real estate is located. Trusts. This involves the transfer of property by the owner, known as the trustor or grantor, to another person or entity, known as the trustee, to be held in trust and either maintained or distributed by the trustee in accordance with the directives of the trust. Trusts can be used to divert income, facilitating the grantor to qualify for institutional Medicaid. Trusts are financial instruments that should be drafted by qualified professionals. Trusts can be designed to either dissolve or continue after death of the grantor. Trusts can be revocable or irrevocable depending on the objectives of the grantor. The individual must have the mental capacity to understand what they are signing and the specific provisions in the document. The trustee may be a family member or other person, or an institution. A revocable trust can be changed or terminated at any time, but has limited protections. An irrevocable trust cannot be changed or terminated and may be designed carefully to qualify for institutional Medicaid. Careful planning is highly recommended, and you may want to leave other funds available for your ready use. While the above are the more formal alternatives, informal arrangements with family members is also a common practice. Please keep in mind that informal arrangements may become questionable once the person loses capacity. While informal arrangements may be quite useful for a long period of time, you may be faced with the requirement for guardianship unless more formal preparations are made prior to the person losing their capacity to make and communicate their decisions. In summary to this part related to financial matters, we hope you will make arrangements in preparation for possible future mental incapacity. Please remember to review your arrangements to make sure they remain current. A good time to review such documents is when there have been significant changes in your life. Unless title to property or financial accounts actually transfers or is changed to permit co-ownership, or unless a trust is drafted as irrevocable, all of these financial instruments can be rescinded by the principal person if they have not been legally adjudicated as lacking in capacity. You should make sure others are aware and have a copy, including copies for your agent, your banker, etc., and you should make time to discuss it with them.